And then I'm also going to turn it over to our Spanish language interpreter, Valentina, to do an introduction.
Thank you, Christina. Hi, everyone. Good morning. My name is Valentina, and I'm here on behalf of Community Language Cooperative, and I'm here to provide and guarantee your commitment to language justice. Language justice is a type of simultaneous interpretation that seeks to create spaces in which no one language is dominant, spaces in which everyone can participate in the language of their heart. So to achieve this objective, we'll be using Zoom's interpretation feature, and what you will see in a couple of minutes is a new little button that looks like a globe will appear on the bottom bar of your screen. Once you see that new little button come up, go ahead and click on it and select either English or Spanish as both the language that you will be listening into and speaking into. If you are joining this meeting on a phone or on a tablet, you will find the same options for interpretation by clicking on the button with the three little dots on the lower right-hand corner of your screen. This button reads more. Hola a todos, a todas y a todos. Buenos días. Mi nombre es Valentina y estoy aquí por parte de Community Language Cooperative y estoy aquí para ofrecerles y garantizar su compromiso con la justicia del lenguaje. La justicia del lenguaje es un tipo de interpretación simultánea que busca crear espacios en los que no dominen ningún idioma, espacios en los que todos puedan participar en el idioma de su corazón. Para lograr este objetivo vamos a utilizar la función de interpretación de Zoom. Lo que verán en un par de minutitos es que aparecerá un nuevo botón que aparece un globo terráqueo en la barra inferior de su pantalla. Una vez que vean ese botoncito aparecer, hagan clic en él y seleccionen inglés o español como el idioma en el que desea escuchar y participar. Si usted está en esta sesión por medio de una tableta o de un teléfono, usted encontrará las mismas opciones para la interpretación haciendo clic en el botón que tiene tres puntitos en la esquina inferior derecha de su pantalla. Ese botoncito dirá More o más. A quick reminder for those of you that do prefer to use English during this meeting, Spanish is 20 to 25% longer than English, so please be aware of your speed. If you have any questions or any issues whatsoever with this technology, please let the whole group know by means of the chat box so that we can work together to address them. Un breve recordatorio es que la interpretación es simultánea, entonces cuando participe, por favor mantenga un ritmo de conversación. Si tiene alguna pregunta o algún problema con esta tecnología, por favor comuníquese al grupo completo a través del chat para que lo podamos resolver en conjunto. Muchas gracias por tenerme por acá. Podemos activar los canales de interpretación ahora. Thank you so much for having me here. We can go ahead and start the interpretation channels now.
Thank you, Valentina. So some tips for using Zoom if this is your first meeting with us or first meeting on Zoom. As I mentioned, the presentation is recorded. Recordings of the presentations are posted on the Division of Housing's website after the meeting. So please keep that in mind as you are making public comments. Also, if for some reason you need to leave early or you want to go back and view previous meetings, know that you will be able to do that on our website. Throughout the meeting, we're inviting public feedback, public comment. You can put comments and questions in the chat box. This is available if you are using the Zoom webinar app on a phone or are joining Zoom on a computer. If you are, you can also raise your hand. You can do that by clicking the raise hand button in the computer or the app. You can also, and the raise hand button is under the React Heart panel. It's on the bottom. If you're joining by phone, you can dial *9. That's the star button and the number 9, and that will raise your hand, and we'll call on you by your phone number. A couple of guidelines for this meeting today. We're going to be talking once again about House Bill 24-1294. This bill, parts of it went into effect on June 4th, so have already become state law. And the remainder of the bill goes into effect on June 30th here, just at the end of the week. The Colorado General Assembly, our state legislature, passes the laws. Our program as an administrative agency can clarify the law if something isn't clear in statute, or help implement it by providing additional guidance or rules. However, we cannot change what is in state statute. We also don't have the legal authority to grant exceptions to the law. So if you do have feedback on the bill itself, we're going to direct folks to speak with their state legislators. We also cannot give legal advice, so please know that information we're going over today is for informational purposes only. You may want to speak to an outside attorney. There are several in this meeting. If you have questions about a specific situation or interpretation of the law and how it applies to you. We're not going to discuss individual registrations or complaints during this meeting. If you have questions about a complaint, about a registration, please go ahead and email us at MHPOP, that stands for Mobile Home Park Oversight Program, at state.co.us, or call 1-833-924-1147. And we'll put that contact information in the chat. Thank you, Michelle and Cassie, for those links. I also wanted to share that there are a couple of different ways that administrative agencies like the Division of Housing can help clarify and implement the law for customers and members of the public. So one is through administrative rulemaking or regulations, and that is part of what we'll be discussing today. What should we propose putting in administrative rules for the program? However, there are going to be other things that are going to be more appropriate for policy document or guidance document from our agency. So just know that if feedback that you provide doesn't end up in draft rules, it may be because we've looked at it and consider it more appropriate for a different type of guidance document. And then, of course, answers to frequently asked questions, information on our website is another way that we can help clarify and implement the law. Just a note that the Division of Housing's website has gone through a pretty big overhaul to make it more consumer and customer friendly. So information is now organized for the Mobile Home Park Oversight Program, for landlords and for residents. We'll also be adding some pages specifically for local government agencies and nonprofit organizations. If for any reason you can't find something on the website, please reach out to us and we can help get you the information. I mentioned in the last meeting that we're going to share information on an updated timeline for this rulemaking. This has not gone out in a newsletter yet, but here's some information on our updated timeline. So we did adopt some emergency rules on June 17th to address items in our regulations that were in direct conflict with state statute now. Those are available and for anyone who wants to view the emergency rules, they're not final yet. They're waiting an opinion from the Attorney General's office, but they went out in our last, copy of them went out in our last newsletter. We are asking for public comments, written comments following these meetings by July 10th. I'm going to file the notice of proposed rulemaking by July 15th. So if you send any written comments that you have, first round of comments, by July 10th, we'll try to incorporate those in the proposed rules. The proposed rules will be published in the Colorado Register on July 25th. And then we'll be accepting additional comments, asking for additional comments. And this is if you want your comments incorporated before we do our rulemaking hearing by August 7th. Rulemaking hearing is tentatively going to be August 14th in the afternoon. And then we'll do a final deadline for written feedback and comments on the rules, which will likely be the day of the rulemaking hearing or a couple days after the rulemaking hearing. We've not sent out draft rules, but we are planning on doing that by early next week so that folks have some time to look at them if they want to comment on that initial draft. And then, as I've mentioned in our previous meetings, we are likely going to do a second round of public rulemaking this year. There are a lot of updates to state law in House Bill 24-1294. And we are doing this first round of rulemaking fairly quickly to address to make sure that we take what's in the emergency rules and which are temporary and make that permanent, and to address things that need immediate clarification. We likely will not be able to incorporate every idea or piece of feedback in this first round of rulemaking. So we are anticipating doing another round of rulemaking this fall. Are there any questions on this updated proposed timeline? Okay. We wanted to start this meeting a little bit differently than the last two meetings and do some open discussion for about 20 minutes. I, recognize some folks on the call have joined the previous two public meetings. Some folks, this might be the first meeting that you're joining, but wanted to provide an opportunity at the beginning if folks have thoughts or feedback after those initial meetings. So we'll do this for about 20 minutes. So till about 10:35, if folks have feedback. We are going to ask that folks limit comments to about 3 minutes per person. We want to make sure everyone has an opportunity to speak, and then follow up in writing if you have written feedback or additional comments you want to make. So with that, I'll open things up for questions and comments. I know I'm still getting my coffee this morning, so no worries if folks don't have anything to say yet. I'll give it about another 30 seconds, and then if not, we'll dive in and feel free to put questions and comments in the chat or raise your hand through the presentation. Okay, I see a question in the chat. What do you know about RV parks being pulled into the act? So recreational vehicles, campers, camper trailers, fifth wheel trailers are not considered mobile homes under the Mobile Home Park Act. So they are not included in the regulations that apply to mobile homes and the owners of RVs, camper trailers, and similar recreational vehicles do not have the same rights as individuals who own mobile or manufactured homes built to the HUD standards. The only situations where an RV park is going to be part of the oversight program and governed by the Mobile Home Park Act is if they have the community has 5 or more mobile or manufactured homes in it, in addition to recreational vehicles. So mobile and manufactured homes are homes that are built for long-term residential occupancy. We do have a page on our website that provides a little bit more information on how to tell if something is a mobile manufactured home that falls under our program or a recreational vehicle. But communities that only have RVs are not part of the program. Communities that have, but if they have 5 or more mobile homes as well, they would be part of the program. And they would be part of the program regardless of whether they are open year-round or only open in the summer months, for example. So one of the changes in House Bill 24-1294 is the mobile home park definition was updated. So the mobile home park definition, which was our definition in our program rules, focuses on whether the landlord has a rental agreement or is receiving rent payments for a mobile home, regardless of whether it's owned by the landlord or independent homeowner. There was previously language around the property being used for the continuous occupation of 5 or more occupied mobile homes, or the continuous accommodation of 5 or more occupied mobile homes. That specific language was removed effective June 4th. Another great question in the chat: if an RV park does fall under the program, does the act apply to every site or just the sites occupied by mobile homes? So only individuals who are renting or who own a mobile home would have rights under the act. However, parts of the act related to maintenance of the property would still apply. So maintenance of the premises, maintenance of common areas. But that may be something we can put out some more clarification on. You only pay registration fees for tenant-owned mobile homes. So if a landlord owns all of the mobile homes in a park and rents them out, the landlord is still required to register with our program and still has responsibilities under the Mobile Home Park Act, but they would not pay a registration fee if all the homes are owned by the park. If a landlord has a mix of RVs and tenant-owned mobile homes, the landlord is only going to pay a registration fee, which is currently $24 per mobile home for those mobile homes, not any RVs. So question about if a park owns a mobile home and rents it, that renter will fall under the Mobile Home Park Act. They will be able to have first right to buy. Not exactly. So renters already have certain rights under the Mobile Home Park Act. This is due to changes in a bill that was passed 2 years ago House Bill 22-1287. So that legislation included renters in certain sections of the act. So for example, renters now have a right to receive the notice of homeowner and resident rights that the Division of Housing puts out, and that landlords are required to post in common areas of the mobile home park and share copies of. Renters are also entitled to certain information on their water bills around the total amount being paid by the community, the total amount charged to all residents. And then another area, for example, that renters fall under is the section of the law on the landlord's responsibility to maintain the premises. So this has been true since that bill went into effect. I think it was October 1st, 2022. Renters do not have a specific first right to buy a mobile home if it is for sale. And there are other rights in the Mobile Home Park Act that don't apply to renters. So for example, if an individual owns a home in a mobile home park, they are going to have greater protections around their tenancy being terminated than someone who is renting a home. Similarly, renters, or kind of on the flip side, renters are protected by another state law called the Warranty of Habitability that includes requirements for landlords to make sure that the unit is habitable, there's running water, there's heat, because homeowners own their unit, issues inside the home wouldn't be covered by the warranty of habitability, for example. It's probably worth mentioning with July 1st right around the corner, residents are going to be able to file, residents who are renting a home are going to be able to start filing complaints with our program starting July 1st. They'll only be able to file complaints about violations of rights that they have under the Mobile Home Park Act. But that is a change that's happening next month for our program as well, and we anticipate sending out some more information on that. So question in the chat about cases being closed when someone passes away. Samantha, we can follow up with you separately on this. We did receive your communications with some questions about cases. There are cases that are still open. If someone passes away, if they have a basically a successor who wants to keep the case open, the program can also keep cases open by initiating a program investigation. So someone being deceased doesn't automatically close a case. Great question in the chat. In a resident-owned community, who is considered the landlord when all residents are owners? I'll be transparent that we are still working through that. In some situations, we may decline to investigate a case when like a co-op can't file a complaint against a management company, for example, because they're both considered landlords. So we're working on some clarification on this. As we know, there are more co-op and resident-owned communities that are coming into fruition in Colorado. A question about how many staff are assigned to handle owner-resident complaints, along with the potential new influx of complaints from nonprofits and renters. So we have 5 staff on our complaint team, 2 program coordinators, 2 specialists, and our complaint program administrator. We also have 2 compliance investigators who are assisting with or conducting site inspections when an on-site visit may be required as part of a complaint. This is a pretty significant change from when the program started in 2020, and when we had only 2 staff for registering all 760 parks and addressing all complaints. So we have made significant adjustments to our staffing to address the cases that have come in and what we've learned about the time required to assist parks with registration. A question about whether we can provide a timeline for resolving complaints that have been outstanding for 3 to 4 years. So our goal is that we will have all complaints filed in 2020 and 2021, the fiscal years for the state, resolved by the end of this calendar year. So those are the oldest complaints that are still outstanding. And as we work on clearing our case backlog, we are also discussing goals for resolving new complaints in a more timely manner now that we have additional staffing. So question about whether these timelines for resolving complaints include when newer complaints are and quote bundled by MPOP with the older complaint from the same person or people. I would have to answer that probably on a case-by-case basis. If new issues are being introduced to a complaint by the person who filed the complaint, that will extend the time that it's going to take staff to complete an investigation. That is one reason that we're encouraging people, if it's a new issue, to potentially file a new complaint, a separate complaint. If program staff are consolidating a complaint, it's likely because we see that the issues are the same or similar enough that it would make sense to investigate them together. But this is, potentially a tip for anyone filing a complaint to assist us with the complaint process is, as much as you can, provide information up front, all of your allegations up front, because every time we get new information in, that has to be reviewed by staff. We have to update information in your case. Like we create a timeline for each case of events, things like that. So the more folks can provide up front, um, that'll lead to fewer reviews. Question about how the homeowner notice can be displayed now that it will be required in 2 languages. So posting of the notice of homeowner and resident rights that's produced by the Division of Housing has always been required in 2 languages. Our rules clarify that all pages of the notice have to be visible and accessible at all times. So what this is going to mean is usually 4 pieces of paper that are posted side by side. We have a 2-page notice for the English and a 2-page notice for the Spanish. In terms of options for other types of notices that now have to be provided in English and Spanish, we're open to input on whether we should provide any clarification on that. But for the notice of homeowner and resident rights from DOLA, all 4 pages have to be visible and accessible at all times, which is going to mean posting them side by side. The park rules and regulations. Got it. So yes, landlords need to provide the park rules and regulations in English and Spanish. I do think that offhand, knowing that those are longer documents, something, rather than having 40 pages posted out, it probably sounds reasonable that you could have something, in a key ring laminated, but it should be easy for folks to see that there are multiple pages. And if it is, on a key ring, folks have to be able to flip through would have to be able to flip through those pages as well. But that's maybe something we can look at more official guidance on as well. But those are my initial thoughts. Oh, interesting question. Do we have any guidance on how far removed a family member can be to be included as an owner under the definition of a homeowner in the Act? Also interested in qualification for EMAP, Emergency Mortgage Assistance Program help. I can look into that and get back to you, Michael. I don't think that the Act defines family member for purposes of the definition of a homeowner. And I can find out about the Emergency Mortgage Assistance Program and what their regulations say. If you have suggestions around whether or not the program should define family member or clarify who is considered a family member in that homeowner definition, please submit those in your written comments. Joyce, to your question on the new law, is it going to affect anything in the Act or just changing the language? So there are quite a few changes to the Mobile Home Park Act that are part of the new law. This presentation goes through some of those changes. We have the slides posted on our website, as well as recordings of 2 previous meetings where I provide an overview of those changes. Question about, do mobile homeowners have the first right of refusal to purchase, assuming the sale of a 150 space RV park with 20 mobile homeowners? So right now, under state law, homeowners have an opportunity to purchase the park and have the landlord negotiate in good faith with them if they submit an offer to buy the park. They do not have a right of first refusal as a group of homeowners. However, a group of homeowners can assign their opportunity to purchase to a public entity like a local government, and then that public entity would have a right of first refusal to purchase the park. I understand that the question here is what if it is a mixed use community where you have RVs and mobile homes? I think that's something we probably need to get some more clarification on. So great feedback and something we'll look into. Question about whether the program can provide resources and links for translation and or interpretation services. Yes, we are going to put a page up on our website with some companies that we're aware of that provide translation and interpretation services in Colorado. It will be something that landlords will have to budget for moving forward. I think you're right about that, Kathleen. I'm not currently aware of any grants available for that, but that's something our community outreach liaison, Michelle, can take a look into for us. Well, this has been great conversation and discussion. I'm going to go ahead and jump into some of the slides we have. Just note, I may skip past some slides today in the interest of time, but again, we do have those recordings that go over all of the highlights of the bill. So mentioned and please continue to raise your hand, put comments in the chat, and we'll address those questions during the presentation as well. I mentioned that some emergency rules were adopted earlier this month to make sure that our rules match state statute. One change I want to highlight here is as of mid-April of this year, landlords are required to provide 72-hour notice before entering a mobile home lot. That is an increase from 48 hours previously. That change was made through another bill, House Bill 24-1098 on for-cause eviction. That bill has some important changes to the tenancy termination process for renters. So if you have a community where you have individuals renting homes from the landlord, make sure that you look at that bill or speak to an attorney about that bill. But it also included this change in the notice required for lot entry. Note that prior notice is not required if a landlord is posting a required notice, a notice that's required by state law or by the lease. There is more guidance in our existing rules on what type of notice is required for different types of lot entries, like for example, meter readings, where it's going to happen every month. And that is in Rule 6. So I would refer folks to look at our existing rule if they have questions on what's required there. Question about guidance on what residents need to do to qualify as a resident organization to whom a selling landlord must respond for opportunity to purchase purposes. So What the statute currently says is that the group of homeowners has to have the approval of 51% of homeowners in the community to make the offer to purchase. They also have to provide proof to the landlord that they have that approval. They don't have to submit the names of everybody who voted to make an offer to purchase. They can submit a document signed, for example, by an attorney that attests to the fact that they have 51% homeowner approval. Michael, can I ask, is there something that you're seeing or a situation where has been confusion around this? And you're welcome to jump in.
Sure. The reason why I was asking was for preliminary information prior to the residents making an offer. So basically requests for some communication with the landlord to get the ball rolling, and have been in touch with a resident group that was just not getting responded to at all by the landlord, declaring them just to be individuals that had an interest, but he didn't think that they were counted as an organization, and so he did not respond to their queries.
That's helpful. Thank you. I think that's something that we can look at clarifying what counts as a group of homeowners for the purposes of requests for information. My understanding is that language group means more than one. But for purposes of getting information, that may not require a formal vote of all residents. So we can look at clarifying that.
Thanks.
So these are some of the changes that went into effect as of June 4th, that were part of House Bill 24-1294. I mentioned some updates to the definition of a mobile home park. Specifically, there is not a continuous occupation requirement. Instead, the law looks at whether the landlord has a rental agreement or is receiving rent payments for the home. The requirement that a property be operated for the quote pecuniary benefit of the owner was also removed. So what this clearly means is that even if a community isn't making a profit, or it's run by a nonprofit or a government or a co-op, it is considered a mobile home park under the Act. And I believe most co-ops and government-owned communities are already registered with the program. There were changes to the eviction process as it relates to our complaint program, and I know we've gotten some feedback on this already. So a resident can provide, if a resident is facing a forcible entry and detainer or eviction action, they can provide, and they filed a complaint with our program about that relates specifically to that eviction action. A resident can provide a copy of their complaint to the eviction court. The court shall automatically stay an eviction hearing for at least 21 days. This doesn't apply if the basis for the landlord terminating someone's tenancy is under 2031F, which is sometimes called a substantial violation. So if the homeowner has done something in the park that endangers people or property, and there's more specific details on that in the Act. While there is the stay on the eviction hearing, our program is encouraged to review and conduct initial assessment of the complaint. We've gotten some feedback that folks would like more information on whether there's a specific time frame in which we'll conduct the review and how we'll be communicating what our assessment of the complaint is. Clarification that landlords cannot charge residents what we've seen called month-to-month premiums. So any sort of fee or penalty for refusing to sign an annual lease or a new lease and instead staying under their own lease on a month-to-month tenancy. The bill clarified that landlords are not in violation of state law if a third party shuts off water to the park. So say the park gets water from an outside utility, a city of X, water district, and the city shuts it off. The landlord's not responsible for that shut off. There is some additional clarification though on when landlords need to provide water and the amount of water that landlords need to provide. When there's a water service disruption, that is the responsibility of the landlord. Excuse me. So if a landlord fails to maintain or repair water lines in the park, the landlord has to provide reasonably sufficient amount of water, potable water, water that's safe for drinking and cooking, within 12 hours after the start of the service disruption, and then a reasonably sufficient amount of water for bathing and all other essential hygiene for all members of the household within 72 hours. We've gotten some feedback at previous meetings that folks, both residents and landlords, would like clarification on what a reasonably sufficient amount of water is. So if anyone has feedback on that, we'd love to look at your written comments. And I see some questions in the chat, which I'll turn to after this slide. So there is clarification in state law now that landlords also have to provide alternative drinking water if the park or residence lot is subject to a boil water advisory. So Colorado Department of Public Health and Environment is one agency that issues boil advisories. But there may also be boil advisories issued by other entities. So that's something we've learned since the last meeting. We might need to clarify. And this water needs to be provided until the agency that issued the boil notice lifts the notice. There's also a requirement in the act that the landlord must post a notice in English and Spanish of each boil water advisory within 24 hours. And this is consistent with Colorado Department of Public Health and Environment's requirements that have already been in place as well. I'm going to turn to some of the questions in the chat. Has DOLA or the state legislature considered increasing the minimum number of mobile homes that the act applies to from 5 to 50 or 100? Compliance with the act is very onerous for small businesses. So state statute defines a mobile home park as a community with 5 or more mobile homes. That is not something that DOLA can change. So that would be a change that has to go through the state legislature. Our registration program administrator, Cassie Vandermeer, is on the call. Cassie, I know you looked up the size of some communities and how many parks we have of different sizes. If you have those numbers offhand, it might just be interesting for folks to see in the chat. But Colorado does have several hundred communities that are under the 50 or 100 home threshold. Question in the chat about whether when there's a water service disruption, if portable toilets still need to be provided. Yes. So that is a separate requirement that is still part of the law. Portable toilets do not need to be provided if there is a boil advisory, which would be a situation where there is water running, but it has not been deemed safe to drink. Question, if water is metered and measured, one reasonable amount of water would be the average daily use in February, a non-irrigation month. That value is used in Golden for yearly billing purposes around sewer treatment, for example. Great, thank you for the comment. And I need to slow down a little bit for our interpreter. Wow, thank you, Cassie, for that statistic. So 321 mobile home parks in Colorado out of the 760 statewide have 20 or fewer mobile homes. So if again, this is not something the Division of Housing could do, but if the state legislature looked to exempt more smaller communities, that would be a third to half of the communities in our state. That would also mean that homeowners who are renting lot space but own their home in those communities potentially would not have rights under the Mobile Home Park Act. I see someone on the phone who may have unmuted themselves, ending in 5314. Is there a comment you wanted to make?
They've been in unmuted status the whole time. I think they just muted their phone directly.
Got it. I'll mention that one question that has come up around the provision of alternative drinking water during a boil advisory is if it's a situation where the boil advisory was triggered because a well had run dry and so there was a pressure loss in the system. The questions come up, well, if we just refill the tanks, if they're holding tanks for the well, is that sufficient? Do we still have to provide the alternative drinking water? And the answer is alternative drinking water has to be provided until the boil advisory is lifted. Which typically those are not lifted until the system is flushed and the water is tested again to make sure that it is free of bacteria. So even if a holding tank was filled, you have to wait until the advisory is lifted, which if it's an advisory going through Colorado Department of Public Health and Environment, they are typically working with a mobile home parks water service operator to do the testing that's required and the flushing of the system for an advisory to be lifted. Another topic we've received some comments on so far are relating to maintenance of the premises. So House Bill 24-1294 clarified that landlords are responsible for maintaining sidewalks in a passable, safe condition and snow removal for all pedestrian sidewalks and other pavements that provide access to public areas. We've asked for clarification around whether landlords or homeowners are responsible for clearing snow from sidewalks in front of homes and from driveways. So if you have feedback on that, we'd love to hear that in the call or in written comments. Comment in the chat that if a landlord has to give 72 hours notice to go onto a lot, that may be difficult to timely shovel snow on sidewalks on that lot. So I think that's feedback we would take into consideration. Another comment, how about snow removal for school bus access? Great question, and potentially another area for clarification. A question in the chat about the impetus behind House Bill 24-1294. I think we will leave that discussion for another day or conversation with recommend reaching out to your state lawmaker or the sponsors of the bill to find out more. And we are going to save a copy of the chat for reference when we're drafting rules. So I might not read out every comment, but just know we are receiving your additional comments on snow removal. And I'm going to start skipping a couple of slides just in the interest of time. So one change folks should be aware of, I mean, these are all changes folks should be aware of, but is effective June 4th, if a landlord is giving a tenancy termination notice to a homeowner, so this would be something like a notice to cure or quit, or demand for compliance or possession, and it's based on a alleged violation of a park rule by the homeowner. There is additional information that is going to need to be provided in that termination notice. So specifically saying what the purpose of the rule is, how the rule is related to that purpose, and how the rule is necessary. Potentially, we've asked whether we need to clarify the notice should say how the rule is necessary to prevent material damage to property or people, which is one of the requirements for terminating a tenancy in the Act. A general comment in the chat, you know, if a mobile home park has a rule in their park rules and regulations that conflicts with state statute, does the park need to amend their rules? It's probably recommended, although I can't provide legal advice on that. And yes, any amendments to the rules would require 60 days advance written notice to the homeowners. Specific to snow removal, we have not clarified yet, and I don't think that the Act is necessarily clear whether snow removal from sidewalks on a lot is the homeowner or the landlord's responsibility. So we're still getting feedback and doing research into that. There's also a comment about how snow removal is done. Could we clarify that snow removal and plowing should not be done so as to block people's carports? This is a pretty significant change related to park sales. So there is a new section of the Dispute Resolution and Enforcement Program law that goes with the Mobile Home Park Act and governs our program that says as a prior condition of a landlord selling or transferring ownership of a mobile home park, they have to inform potential buyers of any outstanding penalties, complaints, or compliance actions that are the result of a complaint that they have with the mobile home park oversight program. Our park sale administrator has been sending out communications to landlords of properties that we're aware may be for sale, letting them know here are the new requirements, here's are any pending complaints, here are any unpaid penalties. If you need documents to provide potential buyers to request that from our program. But we know there are still going to be some questions that come up about this. And so if you are selling a park or are contemplating the sale of a park, be aware of this requirement and feel free to reach out to us with questions or feedback. I'm going to go over now a couple of the changes that take effect June 30th, which is right around the corner here. For any landlord who does rent to own agreements or lease to own agreements for homes in the park, know that there is a new section of landlord tenant law in Colorado on rent to own agreements. It specifically applies to rent to own agreements formed on or after June 30th. Enforcement of this new section of the law is going to be through a private right of action in civil court or the Attorney General's office. It will not be through the Mobile Home Park Oversight Program, but we may be able to assist with education or directing folks to the right place if they have issues with rent to own agreements. Landlords are going to need to disclose, starting on June 30th, rent to own agreements that they hold as part of their annual registration with the program. And we'll be sending out more information in the registration information packet to folks who need to renew their registration on the additional information that they'll need to provide. New section related to condemnation of a mobile home park, or an update rather to an existing section. So if a mobile home park is condemned for reasons that are the responsibility of the park owner, and this is the language from statute. So for example, if there were many, many years of deferred maintenance that the landlord's responsible for doing under state law and did not do. And for example, local government condemned a property and individuals who owned homes on that property were going to have to move their homes or were going to be displaced. Those homeowners could demand compensation from the landlord. And the process for the demanding compensation and the options for compensation are the same as the options if a landlord decides to close a park or close part or all of a park to mobile home rentals. Homeowners can demand relocation costs or that the landlord purchase their home from them. Just on this, I am not aware in the last 5 years of any mobile home parks that have been condemned by a government entity. Maybe others on the call are, but we have not been notified of a condemnation. We are aware of a couple of parks where the owner has closed the park. So rent increases. As of 2022, and that previous bill that I mentioned from 2 years ago, landlords are prohibited from increasing rent if they don't have an active registration with our program or if they have unpaid penalties owed to our program. This most recent bill adds some additional prohibitions around rent increases. So a landlord can't increase rent or issue a notice of rent increase if the landlord has not fully complied with any administrative agency or judicial order. And that could be a final federal, state, or local order. There is also prohibition on increasing rent if a landlord has been found by the division or court to have violated the section of the Mobile Home Park Act on the landlord's responsibilities to maintain the park within the last 12 months. We've gotten some questions and feedback on clarification and implementation of this section. I wanted to highlight that in case folks on this call have additional feedback. So community meetings. This was part of the 2022 law that said the resident can request the landlord hold a community meeting. And the landlord has to do so within 30 days. A maximum of 2 times a year. There were language accessibility requirements added, or that will be added as of June 30th to state law. So landlords have to post community meeting notices in English, Spanish, and any other language reasonably known to be spoken by more than one resident in the park. So for example, we've gotten feedback that many mobile home park residents in Gunnison speak Cora, which is an indigenous language from Mexico. So if you own a park in Gunnison and you know one or more residents speak Cora, you would have to work with a Cora translator or interpreter to provide the meeting notice in that language as well. Residents can also make reasonable requests before a meeting for interpretation and translation. And then here's the language encouraging us to post information on those translation and interpretation resources. Landlords are going to be required to establish unique mailing addresses and mailboxes for each lot in the park, provided that U.S. mail service is available in the area. Question in the chat about whether a landlord can refuse to allow residents to allow the meeting to be available by Zoom. I think that is an interesting question, and I'm not sure if that's answered in the statute, so that's something that we could look at. It may depend whether the Zoom option is being requested for as a reasonable accommodation for someone with a disability or for a different reason. So several requirements around language access that were part of the bill this year. Landlords have to provide required notices, disclosures, and communications in English and Spanish. So this would be something like a boil water advisory, a notice of a water shutoff, notice of a rent increase would all fall under this category. Residents can request notices, disclosures, or other communications in one additional language that they speak. And then moving forward for that particular resident, the landlord needs to provide communications in that language. Residents can also request that communications be provided verbally. And landlords can do this by reading the communication aloud or providing an audio or video recording of them reading the communication aloud. Question about whether there's any requirement that a landlord provide a mailing list or list of mailing addresses to a local municipality, for example. Not specifically, there's not specifically a requirement that landlords provide that information to local governments. There is a requirement that landlords provide mailing addresses for tenant homeowners to the Division of Housing as part of their annual registration. So if a local government or nonprofit was looking for that information, mailing information for residents, they could submit a Colorado Open Records Act request to the Division of Housing to provide that information. We do not collect anyone's names as part of that, and landlords are specifically asked not to include names when they submit mailing addresses to the division. Michelle or Cassie, perhaps one of you can put the link to submit an open records request in the chat. There are also requirements around landlords providing notices and communications in clear and plain language to ensure it's easily understood by residents. So a question about how much landlords are required to provide translation wise in terms of water and wastewater issues. There might be a 200-page preliminary engineering report. Will landlords be required to translate the entirety into Quora or another language if requested? I guess a question here would be whether that report is being provided to all residents and falls under the language here, providing any notice, disclosure, or other communication the landlord is required to provide to a resident. But Michael, if you have feedback on clarifying that, please submit that with your comments. So we are at time now. So I'm going to skip here to information on submitting feedback. So we would like your written feedback on the rules or other things that you feel like need clarification from the program. Please send it to our program email address and include MHPOP rulemaking in the subject line. If you do not have access to email, you can also submit your written comments by post mail. And our address is 1313 Sherman Street, number 320, Denver, 80203. And again, put MPOP rulemaking in the subject line. One last question I see in the chat. Can the mailing address request include a request for a CSV or Excel format? There are requirements in the Colorado Open Records Act laws now that agencies provide information in an Excel or CSV format if that is available. Some landlords submit their addresses in that format, others submit it as a PDF. So it would really depend on how it was provided to us, but we have to provide it in that format. We can't say convert it to a PDF before we give it to you all. Thank you everyone for your communications and feedback. Look forward to additional discussions and looking over your written comments. And July 10th is that initial deadline for providing written feedback to us. And I'm just going to stay on the line for a moment so we can make sure we get the chat saved, but the meeting is adjourned.